Hi everyone, it's Marissa here and welcome to this month's Rise High Live update. Today I am joined by the wonderful Bev Clark, who is a partner at Belperio Clark. And we're going to be talking about relationship breakdowns and specifically providing some tips from a financial perspective and also from a general perspective of things that people can do to prepare themselves for the best possible outcome during a relationship breakdown. Before I get into that, just a few little things that I thought I'd share with you. Firstly, Rise High team are super excited. We've been named finalists in the Better Business Awards, and one of the categories that we're up for is Best Customer Service Firm of the Year. So that's happening on the 13th of Feb. So we'll keep you posted to see how we go that night. So we're pretty pumped about that. Secondly, letting you know that we've got a couple of interesting seminars coming up. We've got a land tax information seminar that we're holding on the 27th of February that you can register for now. We've also got a property investment seminar on the 12th of May that you can register for as well. Also, we do have the Rise High TV page on YouTube that you can subscribe to. So if you're keen to get more updates, then that is definitely a good option. Now, during today's segment, it is, obviously it is a confidential topic for many people. So if you would like to send an anonymous question through whilst we speak, you can actually email it through to emily@risehigh.com.au. Otherwise, you can leave a comment below and we will attempt to answer all of your questions as we proceed through the session. So, Bev, welcome.
Thanks, Marissa. Thank you for having me.
Thanks so much for joining us.
Yeah, my pleasure.
We've loved working with Bev over the years because Bev's one of the top family lawyers in Adelaide, and she's got over 28 years experience in family law and obviously a partner of Belperio Clark. So very, very, the content that you'll bring to us today is just extremely valuable and we really appreciate your time. One of the things that we've loved most about Bev is just she is a collaborative practitioner, which we'll explain more what that means later on, but it's just good to know that we trust what you say is, in the best interest for clients. So not all lawyers out there are sort of, that focused on what's the best thing for the client. But I guess what we're trying to do today through today's Facebook Live is make sure that you're best positioned for the best possible outcome, because relationship breakdowns can be really hard.
They are hard. They're hard emotionally. We're asking people to make the most important decisions of their life that are going to affect the future of their financial position and their children's lives at a time when they're feeling hurt, crushed, devastated, surprised, and they can't think straight. So
and it is, unfortunately, relationship breakdowns are also very common.
Absolutely. They say 1 in 3 marriages end in divorce. There are no statistics in relation to de factos, so anecdotally, I think about 1 in 2 relationships don't survive.
Yeah, so we know that it is a part of life. Relationship breakdowns do happen sometimes, and we just want to make sure that you're as well prepared as possible. So please feel free to share this with your friends that you think could benefit from it as well. Shout out to Rue, Katie and Marissa. Thanks for tuning in, guys. Please feel free to ask your questions as we go. We'd love to hear from you, or potentially your comments. If you've had an experience of something that's helped you through a relationship breakdown, then that's something that we'd love to hear from as well. We're going to get straight into it. There's quite a few questions that have come through from our clients over the course of the last few weeks, and then I want to finish up with your top 5 finance tips. And as a special bonus to you today, we actually have Bev's top 5 general tips when going through a relationship breakdown that we're giving away as a freebie. So that will be available after the video. You'll be able to see the link to that in the comments section and you'll be able to download that. And I really think it's so valuable. So definitely if this is, if you are going through a relationship breakdown or you know someone that is, get a hold of this freebie because it is worthwhile. So, got our first question from Tom.
Yeah.
So Tom asked, him and his partner have decided to part ways. What should they do? He said, should we seek expert advice or do it ourselves? So what would you say to Tom?
I would say definitely get expert advice and do as much as you can yourself. So it's a two-way street. I think that just because you see a lawyer and get some advice about your legal entitlements and how best to proceed, doesn't mean that you're locked in stone with that person. So in our firm, we really encourage what we call kitchen table. We say, come and get some advice, work out what would be a fair offer to put, and then see if you can negotiate yourselves, because you'll save yourself a lot of money. And as part of that, obviously get good financial advice.
Yeah,
because you don't know what you don't know.
I think that's a really good answer, because often we have people come to us that are just at the starting points of a separation, and they sort of ask the same question. And I love telling them, especially if their relationship is still one that they can actually speak and communicate, if they can actually sit down and just go through everything together.
Absolutely.
And talk about, in an ideal world, who would get what and how would it all end up. It makes for such a better process for everybody.
Oh, absolutely.
And it would say, it will save them tens of thousands of dollars potentially by just having that chat up front.
Absolutely. And also a lot of angst. I think that when people only communicate through their lawyers, through letters that are received in their letterbox, I think that sets up a platform where both parties then feel the need to be represented.
Yeah.
You have no control over the style of lawyering that's happening on the other side of the fence. And some of the letters that we see are quite provocative. And so that's an unhelpful approach. It's an expensive approach. And I think it sort of polarises the parties, and it certainly does nothing for their ability to co-parent when the only communication is through lawyers' correspondence.
Absolutely.
So
Tom, the answer is try and sit down with your partner to see if you can nut out as much of it as you can, but also do get some advice as well. And that's would you say that it's best to get that advice after they've had that conversation, ideally, about, in an ideal world, this is how it would look?
I think that it's best to get some advice early in the piece, actually, because before people even start negotiating, we've seen people who have come with what they think is a good deal. We've talked together, we've got a deal, and then it's a real problem if realistically that deal is either not capable of being actioned. So, for example, they find out, sadly, they can't refinance the house as they assumed they could, so they haven't had their financial advice, or there's some tax implications of what they're proposing to do that they haven't factored in, or the lawyer pulls the deal apart because it's not tenable in the sense of, at law, we might not be able to sell that to a judge if we had to have a consent.
And you've also got situations we find where sometimes in the emotion of the relationship breakdown, it is hard to think about all the consequences of what they're committing to. Yeah. So especially if, it's a husband and wife family business and one of them's walking away from the business but ending up with property assets, that might be an okay deal from an asset perspective, but where's their future income going to come from and how are they going to support their lifestyle? Correct. So sometimes it's not... sometimes there's other implications down the track that may not be obvious as you're sorting through things. So that's where, expert advice can play a big role. Yeah. So I feel like we've sort of answered Tom's question. So we'll move on to the next one. But before we do, shout out to Richard, Alex, Emily and Laura. Thanks for tuning in, guys. If you have any questions, please feel free to leave them below. So... Sharon actually wanted to know what are the risks of doing separation without getting any lawyers involved. So we have actually had some clients that have managed to go through the whole divorce process without having any lawyers. And there has been some successful cases where that's been okay. What are your thoughts about that question?
It's really tricky. I also see people who've done everything themselves without a lawyer. And sometimes it's a disaster and sometimes it isn't. It depends. Yeah. So if a lot of people who have reached an agreement and they've shook hands and they've written out something, even recording what their agreement is, if that isn't recorded in a binding way, it can come back to bite them. And I've seen someone up to 10 years after the event where the other party has changed their mind and they never recorded it in a final way. Yeah. And then they can come back for another bite of the cherry. So for most people, even if they get a deal, they want to know that what's theirs is theirs and it's going to stay theirs. And so most lawyers would recommend, me included, that if you've got a deal, then that's the time to actually record it in a binding way. And they probably need to get some legal advice in relation to how to do that.
Look, I couldn't agree more, and I'm looking at it from the finance perspective, because also from the finance perspective, if you are going to change the ownership of a property, for example, the banks want to know that your ex-partner's not going to have any recourse to that property following So they actually want to see a binding legal agreement or a court order or some sort of legal document that will stop your ex-partner having recourse or a right to that property post-settlement. So it's really important from every perspective.
And you would see also, Marissa, the rollover relief that people get from a binding financial agreement or from a consent order in relation to GST. Capital gains tax.
Absolutely.
So,
and I think the other thing as well is that, often when two people decide to go through the process without a lawyer, that generally means they're on pretty good terms.
Absolutely.
And that's really the only way that you could do it without a lawyer, I think, if you're on pretty good terms with your ex and you're both on the same page. And that might go along smoothly, but then one day, one of you meets a partner who's not quite so kind about the situation and potentially can put ideas into one of the partner's heads about going back for a second bite at the cherry.
Well, things can go wrong. I had a case some years ago where the parties sold their house, they split the money, they got half each, they were both happy with that. The wife ended up working 2 jobs to buy another house and pay off her mortgage so she could be back in the same position when she retired. The husband took his half, went to Queensland, bought a business, and 8 years later went broke. Yeah. And when he was back was against the wall, he was looking for advice from people up there to see how he could get out of the financial mess he was in, and all sort of spotlights pointed back to, you never did settle with your wife and she now has a freehold house and let's have another crack at it. So it's really dangerous. But having said that, there are sometimes, occasionally I'll even say to people, do you really want to spend the money on getting an order? If they're really high functioning, there's not a lot that they're arguing about and they are willing to take the risk.
Yeah.
Then there are, it might be they don't need to record it, but that would be few and far between.
Yeah. So I think the bottom line is, if I could just summarise, is that do as much as you can without a lawyer, but make sure you do get some legal advice and preferably earlier on in the piece, as Bev suggested. And I would also add there that it's important that once an agreement has been reached, that you do actually have a legally binding agreement between yourself and your ex to make sure that you've dotted all the I's, crossed all the T's, and the agreement is final, and that's moving forward, that's how it will be.
And I was going to say, people sometimes when they're reaching agreements and they haven't had any advice beforehand, they don't know what else to take into account. So I see a lot of people where they say, we've reached an agreement, we just want you to record it. And I'll ask them, for example, well, how much superannuation do you have? How much does your spouse have? We're keeping our own super, so I don't know how much my partner has. And I say, well, okay, if your partner had $500,000 in superannuation and you only had $20,000 in superannuation, would it still be okay after a 25-year marriage to just leave superannuation out of it? No, if it was that much, but I don't think it's that much, but how do you know?
Yeah.
So if it depends on...
And that's quite common. A lot of couples, one spouse doesn't necessarily know what the other spouse has. I mean, we've even met couples that have been married for 20 years and they don't actually know what their partner earns.
Exactly.
And definitely don't know what their superannuation. Right. I mean, most people don't know their own super balance, let alone their partners. So, they're really big considerations. That we've even seen situations where, one partner is a high income earner and actually hasn't disclosed to their other partner what they're actually earning. And they've been building savings or share portfolios on the side that their partner's not aware of.
Exactly.
So it's just, So
it's all fine to say, I'm keeping what I've got and you keep what you've got, as long as people have shown each other what they've got.
And that's... I've got a shout out to Giselle and Catherine. Thanks for joining us, girls. So the next question that we've got is still from Sharon, actually, and she wanted to know, what do I need to take care of from a financial point of view? So that's a fairly big question, but I guess we've sort of answered the fact that initially it's really an information gathering exercise to make sure that you are 100% confident that you know everything there is to know about the assets, liabilities, income and expenses. Would you agree?
Absolutely. The starting point, I think, is knowing what's in the pool.
Yeah.
And it doesn't matter whose name it's in. Knowing everything that there is that either party may have or have an interest in, even if they're sharing that interest with third parties, and knowing how much it's worth.
Yeah.
So ascertaining values, working out what's in the pool. There are a lot of hidden assets that I think get overlooked, such as someone might have 25 years worth of long service leave entitlements they've accrued or annual leave entitlements they've accrued. It might be an asset if they could cash it in.
Yeah.
But making the inquiries, working out what the asset pool is, working out how much it is, that's a starting point.
And I would add to that it's equally as important to understand what your living expenses will be post-separation, because often it's hard enough to really know what your living expenses are now, but I always encourage clients that come to us that are thinking of separating to really just actually try and do a bit of a budget or a spending plan as to what their living expenses will look like post-separation, depending, and that should take into consideration how much time they're going to have the children, so that they actually know what income they need later on, because that's an important consideration as well, I think.
That's really wise advice, Marissa. And I think that also helps them to figure out sometimes how best to, if they're on good speaking terms and they're very cooperative, they might choose not to set their child support based on the child support assessment. They might choose to actually work out what's our budget, how much does it cost to raise our children in the way we wanted them raised, and how can we both afford that if that's still important to us both. Or they might just go to the child support agency. But knowing what their budget is, knowing how they're going to be able to afford to live beyond their separation will help inform them in relation to how much they need financially, either by way of support or by way of a settlement.
I guess, we've probably spent a bit of time talking about couples where things are on good terms, but there are situations where couples that are breaking up are not on good terms. And in that situation, there probably are some extra financial considerations. For example, I can think of one from a finance perspective. If you've got money in a redraw account, or you've got a joint line of credit, or you've got joint credit card facilities, you might want to take steps to ensure that your partner can't spend those savings or spend that credit card limit without your knowledge. So what you can do is, on accounts that are in joint names that have a redraw facility, for example, you might have your home loan and you might have 20 or 30,000 in redraw available in that home loan. If you've got that set to any design and there's internet banking access, there's nothing really stopping your partner from just taking all of that money out and doing whatever they want with it. So maybe changing your signatories or, changing that aspect with the bank would be a good idea. Also with credit cards, if there's specific credit cards that are in joint names and, there's some money that your partner could take out in that credit card, then maybe you need to think about how you can protect yourself in those situations. Is there anything else that you would suggest for, protection where they're not on good terms and sometimes even trying to do spiteful things to sort of hurt the other party? Like what can our listeners really do to protect themselves to make sure that their partner's not going to make the situation worse?
Changing passwords for a start.
Oh, that's a really good one.
So
and that would include on your things on your email, on your phone.
We've seen some shocking abuse take place where people have been able to access somebody's social media, emails, sending out emails to all their contacts of a very damaging, inflammatory nature. Recognising, of course, that no one has to put up with violence and abuse or stalking, and that might be an issue that police might need to be involved in to take out protective orders. So in the really bad cases, that might be necessary.
And that would also be for your internet banking. Make sure you change your password, absolutely.
Change all your passwords. Because we all share, well, not all of us, but a lot of us share all that stuff with in our intact families, with our spouses. We treat it like we're all. And
especially if you are still living together, or if you have used their device to log into your, log on to your internet banking or your social media in the past, then the device might have kept the password, I guess, potentially.
And you might also want to, if you've got precious documents or memorabilia or something that's really precious to you and you're feeling that they're vulnerable if you're in the same household, you might want to move that to another location. If you feel like your partner...
Would you say like a bank safe or another...
Or your parents' house. Somewhere where your partner can't access it if you're worried. I always think these things need to be carefully considered, because the first person to do those protective measures, if it was overkill for them to do that, that can be provocative in itself. So we've got to be careful.
So there's a fine line.
It's a fine line. Yeah. I know some lawyers will say to people, empty the bank account, and that saves the other, stops the other party from doing that. Yeah, but the minute you start that, it's like starting the war.
Yeah.
And you've got to live with the fallout.
And
so you've got to be a bit careful and balanced.
I think that's one of the things that I've always respected about you is that you do encourage, I think I mentioned that you're a collaborative practitioner, and what that means is that you're one of the few lawyers that recommends not going to court and recommends trying to collaborate and negotiate to reach an agreement well before it gets to court. And I really like that approach because I just feel like it's better for the client generally not to go to court if they can avoid it.
100%.
I mean, in some situations it can't be
exactly.
avoided,
Correct.
but in other situations there might be the ability to work through things in a gentler way.
Absolutely. We think of it as a less, we like clients to start with the least invasive, least costly approach to them.
Yes.
My bank manager and my husband would love it if every one of my clients litigated and we rushed off to court. That would be better for me. That would not be better for the client or the family. So start with the least invasive and only move up the chain and only go to court as an absolute last resort, which most families don't need.
Yeah. That's great advice. Shout out to Leah, Julian and Serena. Thanks for tuning in, guys. Welcome to the show.
And Marissa, can I just add the other thing I was going to say about when we're talking about protective measures, might also be changing your binding nominations on your superannuation.
Oh, that's a good one.
Because if you, and also severing joint tenancies.
Yes.
So if you're a joint tenant in a house and you died before you've issued proceedings or settled your matter, that house is automatically going to pass to your spouse. So you might want to sever that joint tenancy.
Absolutely.
In the lead up to the settlement if it's an
and would you
matter.
So that's changing your beneficiaries on your superannuation insurances. Would you also redo your will at the point of separation or at the point of divorce?
You certainly get some advice about redoing your will early because even people who have life insurance that will land in their estate, they might not want that, so they might be stuck with certain assets that won't form part of their estate in the event that they die before the end of the matter. But I think it's really wise actually to be looking at their wills early in the piece. And
that's possible because these matters generally take a while. So would you say like generally over 12 months?
They absolutely.
So it's not impossible that you would die, regardless of your age, in between the time that you separate to the time that you get divorced. And if you do have dependents or children, or other family members that you would prefer to, have those assets handed to, then that really is quite an important consideration.
And I see clients who come to us whose marriages have broken down because someone they have a terminal illness. How sad is that? So someone discovers that they're terminally ill or incredibly sick, and their partner takes that moment to say, "Oh, actually, I think I'm out of here. I don't want to care for you. This isn't what I signed up for." And their marriage breaks down. Their whole life is falling apart. So they're the people that are financially and emotionally vulnerable.
Hard. Yeah.
And so it's quite possible if they died before they get to the point of resolving it, we have to think about, well, who would get your estate, and would you want that still?
Another, that's a tricky situation. But another thing that just popped to my mind as we talk, thinking of more things, is that if you do have an unencumbered property, so you might actually own a property with your spouse that doesn't actually have a bank loan on it. If you want to protect, or it might not be in your name, so it might just be in your spouse's name. If you want to protect the ability for them to be able to sell that without your knowledge, you could put it, register a covenant over it. And that would just mean that you would be informed before they could take actions to sell the property.
Well, they couldn't do it. They wouldn't be able to transfer it.
So
they lodge a caveat over the property. That gives them
another extra protection.
But again, as I said, you've got to always think about, there's lots of protective things you can do, but do you need to? You have to carefully consider that, because if you start that process, then that creates a difficulty for the other party that they may then retaliate.
And that's where advice from preferably a collaborative lawyer would be actually really helpful, because a lawyer that is just focused on litigation would probably tell you, lodge a caveat.
Oh, absolutely.
Just go for it, go for gold. So, that's great. We've had a question come through from Emily. Is that the same with vehicles? So I'm assuming that she's talking about, vehicles that maybe one party owns.
I'm not so fussed about vehicles. They're generally not a really high value asset in the grand scheme of things. usually in the sense of possession's 9/10 of the law. If you've got the vehicle in your possession, you can hang on to it. It doesn't matter whose name it's in. Family law doesn't care whose name things are in. So if it's your vehicle, you're habitually driving it, and you separate, but the vehicle's in your spouse's name, hang on to it, and the registration and resolving the ownership issue will be resolved at the end of the day.
Okay, so what happens in that situation where, at the end of the divorce, the registration would change name? Is that what would happen?
If the parties agree and they get a consent order or a binding agreement that says the wife, for example, is going to keep the vehicle, and the vehicle is registered in either joint names or in the husband's name, then as part of that order, it would require the registration to be transferred.
I guess the only complexity comes into play when the car has debt over it.
Yeah, correct.
So a vehicle lease, in which case then that would probably need to be transferred a bit earlier.
Or correct. They have to resolve the issue of the debt. So it either has to
the debt will need to be paid out, or the
or
person who's going to take over the vehicle would have to borrow the money in their name.
Yeah, and that's where people need financial advice, Marissa, because sometimes people have all sorts of intentions in relation to what they're going to do with the house or their cars. But if there's finance involved, it isn't necessarily simple. They can't always just transfer the finance over to the other person. They need to know, is that
that can be trickier than it sounds before you've got a formal divorce agreement, because up until that point, many lenders will see that as a not an arm's length transaction between husband and wife, and it is a second-hand vehicle. So the finance options will be very expensive for that situation. Perhaps once you've got the divorce agreement and it's not seen as a, does that make sense?
And there's other complexities. Sometimes vehicles are owned by a company.
Yeah.
They're not owned by the parties in their name. They treat it like it's their own asset, but it's actually owned by a company. So they've got to get it out of the company.
Yeah. So then it's really a sale of asset.
Yeah, or a transfer, and then they've got Div 7A issues and potentially tax issues that might flow from that. So
they need to get their accountant involved too.
They need to get their accountant involved. Yeah.
So hopefully we've answered that question. So Sally wrote in and she wants to know, what are my options with the property, whether I decide to sell or retain. And she said, if I wish to retain out my house, what do I need to do?
I think the absolute starting point is not if it's financed, or even if it isn't, if for you to retain it, you're going to have to pay out the other party's interest. You're going to need to borrow. If you're going to need to borrow money, you need to know realistically, can you? Yes. And that's where I think getting advice from a mortgage broker or a finance broker, understanding what you're capable of borrowing before you go down the path of having a dispute or a negotiation that involves you keeping the house, if realistically that's just not feasible when it comes.
Because there's really two questions. There's can you afford it, which is the practical sense of can you actually physically afford the repayments. But then there's also, do you have the borrowing capacity? So will the bank lend you the money in your own name post relationship breakdown to actually be able to do it? So it's do you often see people that
I see lots of matters where, as an intact family with two incomes coming in and living in one house where they're only funding one house, they absolutely can easily afford to have the properties that they have. Once they've separated and they're running two separate households, they can't live the same way. And the banks are going to take into account their separate incomes for whatever their new future looks like. And it might be a whole different picture. So I've seen too many people spend too much time negotiating a certain outcome. I'm going to keep this house and you're going to keep that house, when realistically neither of them have the capacity to either borrow enough money to pay out the existing mortgage, let alone buy out the other person's interest in that property. So,
I think that's really good advice. So I would also agree that before you do decide whether you're going to sell or hold on to the home, or even any other investment properties for that matter, definitely you should be speaking to your mortgage broker to see what your borrowing capacity is and what is actually possible for you from a finance perspective. And then there's also the matter that it's probably also worthwhile to, even if you do have the borrowing capacity, it is worthwhile to talk to your mortgage broker about, some people that we see, they actually do have the capacity to take over the family home. and that's what's going to happen in the arrangement, that they will take over the family home. But due to emotional reasons or having too many memories in that home, they actually don't want to keep it.
Yeah.
So in those sort of situations, we actually had a question come through, which I'm just looking at where that is, but we had a question come through that if they have been given the family home but they actually don't want to keep it, what do they do in that situation?
Okay. So if that's, I'm assuming that they mean after they've settled everything and they've got
Yeah,
a binding
they've settled,
agreement or they've got a
yeah.
consent order, and the house has been transferred to them and they want to sell it, they can do whatever they like with it.
Yeah.
So once they've got an asset that becomes theirs as part of a final and binding outcome, then it's theirs to do what they want.
Yeah.
We see a lot of people where they do it the other way around. They've during the relationship, during the breakdown, but before they've finalised everything, they want to sell an asset. But they don't want the other party to share in the gain
The
from it.
profits. So can that be done?
No, not really.
No.
Not other than by agreement.
So if you want to sell it, you really have to wait till after the separation.
or you have to agree with your spouse that you're going to sell it. So
And
then whatever you get for it is in the pot.
Yep.
So in other words,
Okay.
if someone says my spouse is prepared to agree the value of the house at $500,000 and I want to keep it at that because I know that I could sell it for $800,000, but I don't really want to keep it, I want to sell it. You can't have everything.
Yeah, so in that situation, you'd have to sell it after the divorce is finalised.
Yeah.
And I think, we've had many situations where maybe it does make financial sense for them to keep their home even though they don't want to continue living in there. So you don't necessarily, if you don't want to live in there, you don't necessarily need to sell it. You could rent it out and rent somewhere else or buy somewhere else. So consider that option as well. Yeah. Shout out to Tanya, Darren, Anna and Sineth. Thanks for joining us, guys. So moving forward, just going to check where we're at with our questions. Jack wants to know what's the costs involved in transferring a property through a relationship breakdown process. Because obviously normally when you buy a property there's stamp duty and government costs. What are the costs involved when you're doing it through a divorce process?
Well, there's obviously the cost of getting a consent order drafted. And finalised. You're probably looking at a few $1,000s, but it depends on how complex the orders are going to be. So it doesn't just deal with the house; it's going to deal with the overall package of their property. So it depends on how complex that is. And then the only other cost, the same conveyancing costs you pay if you bought a house, except there's no stamp duty on that.
So the stamp duty is exempt. Is that just for the owner-occupied marital home, or is that exempt for all properties? So if they have a number of investment properties, for example,
it's only exempt in relation to the home, the family home.
The family home. So if you've got a couple that have got 5 investment properties, for example, then the marital home would be stamp duty free, but changing the ownership structure of the investment properties would incur normal stamp duty. In which case, is that correct?
I've got to actually, Marissa, I just can't. I think there is an exemption. It's exempt from stamp duty, but under the Section 71, I think it is, of the Stamp Duties Act, I think it's. I actually would have to relook at that. To be honest with you, I've just gone blank about
Could
that.
we maybe put some notes?
I will.
Put some notes in the comment section about that just to clarify that, because
I will.
if stamp duty is payable, or even the conveyancing costs can add up if you've got a few properties, that really needs to be taken into consideration when deciding on the final settlement.
Of course it does.
Because
transfers,
it's not just the value of the assets.
So it's definitely the case that the family home is exempt from stamp duty, so they transfer that to one to the other, and they're not going to pay stamp duty on that. An investment property, they're going to get rollover relief in relation to their capital gains tax.
Oh, that's good.
So they don't have to, whereas the capital gains tax will be payable at some point in the future, it doesn't trigger a capital gains tax event
at that
when it's
point.
Transferred from one to the other.
Yep.
So there's some savings there.
Great.
And the other thing I was going to say, they do have to take into account, we've seen a few lately, is if they've got a mortgage that's interest-only mortgage and it's for a fixed term, then there may be break fees, and some of those can be.
Well, that would be the same if it's principal and interest, but if it's fixed term.
It's fixed term. So we've seen some of those where the break fees were like $80,000. It was massive.
Now, on that topic, we have had some success with some lenders being able to get them to waive the break fees in the case of relationship breakdown.
Okay.
So
again,
push that question a bit further, because the break costs can be astronomical,
Yeah, absolutely.
especially if the loans are fixed. So in the case of, you know, a relationship breakdown, there have been situations where we've been able to get them significantly reduced, if not waived, because of the situation of the divorce, effectively. So that's another good tip.
Yeah.
David sent through a question. I've received settlement for my separation, would like to purchase a new property. Is this possible? What are my options? We probably already addressed this a little bit.
As long as they finalise their property, as long as the property's been finalised in a binding way. If they've shaken hands and sold the house and he's got his half and they've just distributed it, and he's got that half and he goes and buys another property, that property's going to be in the pool if the other party changes their mind.
So basically,
So,
don't do anything until you've got a finalised, legally binding agreement. Which is that? Is that what you're saying?
And then you can take your settlement, you know, if the order says, if the final consent order says house gets sold, husband gets this much and the wife gets that much, they can take their share of it and do what they like with it.
Yeah. And Donna actually wrote in a question, I have a new partner, how do I protect myself? And do I need to?
Don't have a new partner. Get rid of him. Live in the bubble, don't have any new partners. Right. You can only protect yourself by what used to be called a prenup. They're a Section 90 agreement, and they're made prior to the marriage or prior to whilst you're in a de facto relationship. And so it sort of anticipates what's going to happen if this lovely, stars in your eyes kind of relationship falls apart at some future date. They're really fraught with danger, and most lawyers don't recommend them simply because people spend a lot of money getting these documents drawn up, and there's no guarantee with them. Because what I can guarantee is at the end of a relationship, whoever is the financially weaker party is going to try and wriggle out of that agreement. And the courts are very quick to let them, basically. So is
there really nothing that can be done to protect?
Short of just not having any relationships. There's nothing you can do to protect yourself. At best, I would see a prenup as being a hurdle.
And that's really difficult because we've serviced a lot of females that have been through like a marriage breakdown, and they've ended up in a reasonable position, with a house and to support the children and then they want to protect that because if they end up in another relationship and then potentially that breaks down and they could potentially lose their house, what position does that leave them in with their supporting their children? So it's pretty disappointing that there isn't really a stronger protection mechanism in that situation.
There are cases where prenups have been upheld, but there are plenty of cases where they haven't, and that's why we say we can't guarantee them.
Yeah.
But the times when they're not upheld are those, they call it when there's already blood on the wedding dress. Like the people are about to get married, the invitations have gone out, the dress has been purchased, the venue's booked, and a week before the wedding, the rich member of the team, the husband or wife, the person with all the money who wants to protect it, delivers the prenup and says, sign this, or the wedding's not going ahead. They're the ones where the courts are going, whoa, we don't like this. It's got a bit of a stink about it.
So would you suggest that if someone does want to get a prenup just as a bit of extra protection, knowing that it's not bulletproof, they should do it early on in the relationship?
Early on in the relationship. And I also think that it would be the perfect opportunity for a collaborative style of negotiation. So what normally happens is the financially superior party has their lawyer draft up a document that is very beneficial to them and has nothing in it. It's basically, I keep everything I've got and you get nothing. And then the financially weaker party has to either take it or leave it. And so what I think would be better is if they actually had a collaborative style of negotiation where before any documents are drafted, both parties can sit down with their representatives and talk about what would be a fair thing if their relationship broke down, what should be in a document, and then if they reach an agreement, then get the document drafted. I think that's much more likely to be upheld because it's from a level playing field where they're both represented, it's fair, they've had an opportunity to have some input into what would be the terms of that agreement, as opposed to it just being presented to one party and they have to sign it or not.
So if someone wanted to go through that process, which sounds quite good to me, quite logical that would be a good process to go through anyway, what would the cost of something like that be?
It depends.
Sorry, I'm putting you on the spot.
No, it would be very expensive. It would be very expensive. Most lawyers, when they're drafting prenups, are charging upwards of $10,000 simply because they're risky. They're risky documents.
Does your firm do prenups?
I don't do them. I advise on them.
Yeah.
And I have done the odd one. I would do them where where it's a fair document. The ones I see that I won't do are where a client wants me, the multi-millionaire wants me to draft a document where, regardless of whether they're married for 5 years or 25 years, regardless of whether it produces no children or 5 children, 3 of whom might be disabled, the other person still gets nothing at the end of a relationship. I won't draft those because I think my head's going to be on the chopping block, because guaranteed at some point in time the other party is going to issue proceedings about that.
Yeah.
So I won't do those.
Yeah.
But
excellent. So we are reaching our time limit. So I want to just quickly wrap up and summarise the top 5 finance tips for rebuilding your life post separation and divorce. So we've talked a lot about lots of tips throughout the segment.
Yeah.
But if we can just summarise with the top 5 finance tips, that would be great.
I think the top 5 would have to be work out what's in your asset pool. So understand what's in your asset pool, including any kind of hidden assets. Work out how much everything is worth so that you're negotiating from a fair place. Consider what contributions have been made during a relationship that you ought to get credit for or give the other party credit for. So inheritances or windfall gains or substantial gifts from family or friends are relevant and need to be taken into account. Get some good legal advice so that you start with the right negotiation, the right process, and a good understanding of what would be a fair outcome. And get good financial advice, because you don't know what you don't know, and there might be opportunities to save tax, to save costs, and to not go down a path of negotiation that's not tenable.
Absolutely. So definitely, I think there's some great tips there, Bev. It's been fantastic. I think we've lots of nuggets of gold throughout that segment, and obviously it is a complex issue, and every relationship is different.
Absolutely.
And every situation is different, so it's not a one-size-fits-all approach.
If it was, there'd be an app on my iPhone. Plug in the variables.
We understand that it's an emotional and a complex time in your life, so definitely reach out to either Rise High or Bev at Belperio Clark if you've got any other questions. We will have a free giveaway, which is Bev's top 5 tips for getting through the separation divorce process. Is that what you'd call it? Yeah. So that's going to be available as a download in the comment section below at the end of this video. So please make sure you get that. It's a free resource that will be very, very valuable to you. And we'll put some more information about the stamp duty stuff up on in the comment section. Yes. Thank you very much for tuning in. Just a reminder that we've got a seminar about land tax coming up and a seminar for property investment coming up. So land tax on the 27th of Feb, property investment on the 12th of May. So make sure you register for those. Seats are filling up fast, especially for our land tax seminar. We also have our YouTube page, Rise High TV, where we upload regular content about property, finance and money. So make sure that you subscribe to that too. Thanks so much for tuning in. Thanks for your support. We'll see you again next month. Bye.
Bye.